Enga mana, enga reo, enga rau rangatira, o ngā hoa whā, tēnā koutou katoa. Good evening, my name is Bryony James. I'm the Vice-Chancellor here at Te Herenga Waka, Victoria University of Wellington. It is my very great pleasure to welcome you all to the Sir Kenneth Keith lecture. I would like to welcome in particular Sir Kenneth's wife, Lady Jocelyn. We're honoured to have you with us this evening. And also a warm welcome to Ben Keith, who we'll hear a few words from towards the end of the evening, and to other members of Sir Kenneth's family and friends. Welcome to this event. Welcome to the Chief Justice and current and former members of the Supreme Court. This lecture is given every 3 years, each time the conference of the Australian and New Zealand Society of International Law is held in Wellington, so a special welcome to our ANSIL conference delegates. The lecture this year comes with great sadness, as Sir Kenneth's passing is so recent. But I am grateful we have the chance to gather and honour Sir Kenneth, who had an extraordinary impact on the development of legal thought in Aotearoa and internationally. His enduring influence on our Faculty of Law cannot be overstated, and we are honoured that he chose to spend so much of his career here. This influence has just been commemorated with a door plate at the Old Government Building Room 146, Sir Kenneth's room, which is now called the Kenneth Keith Room, and I'm pleased the faculty was able to honour him in this way. It is now my pleasure to introduce our guest speaker for this evening, Judge Kevin Riordan. Judge Riordan is the Judge Advocate General of the Armed Forces and Chief Judge of the Court Martial of New Zealand. Proud to say he is an alumnus of this university, having graduated in 1982 with a Bachelor of Laws and a Bachelor of Arts, and was later admitted to the bar that following year. He holds a Master of Laws from Cornell University and has over 40 years' experience in legal practice and teaching law. That teaching experience includes right here as an honorary lecturer at Victoria University, as well as being part of the faculty of the United Nations Regional Course on International Law. Kevin was head of the legal team of the New Zealand Defence Force for over a decade, reaching the rank of brigadier. He has provided top-level advice on all legal aspects of armed forces operations, including the law of armed conflict, counter-terrorism, and operations law. He has contributed to the development of international law in a number of areas, including regulation of conventional weapons and the banning of cluster munitions. He led the team which substantially reformed the New Zealand military justice system in 2007 to achieve greater compliance with human rights law. And he's also a member of the expert group of the Commonwealth Military Justice Programme. Tonight, Kevin will share his thoughts on the insights, achievements, and influence of Sir Kenneth Keith. He will draw on Sir Kenneth's academic writings, teaching, and judicial decisions to demonstrate that international humanitarian law is not only worth fighting for, it is a foundational necessity. I know I speak for all of us in saying how privileged we are to hear Kevin's reflections on Sir Kenneth's immense contributions, and I'm delighted that we're able to honour Sir Kenneth's memory in this way. Please join me in giving a warm welcome to Judge Kevin Riordan.
Thank you. Thank you. Thank you very much. Can you hear me all right? Because I can certainly hear me all right, so that's good. So, thank you so much for those introductory comments. Kia ora, hui mai, anō toto katoa. Ka tangi te titi, ka tangi te kaka, ka tangi hoki aho. Tihe Māori ora. I te whakaronga mai. It's a very great honour for me to speak here today, and I want to recognise all of our honoured guests. Lady Jocelyn Keith, other members of the Keith family, many of whom I have met tonight and others that I've known for some time. Thank you for giving me the honour of being able to speak to you about someone who is so important in your life. Chief Justice David Hamilton Kelvin, thank you very much for coming along, and I'll spread your mana over all of the judiciary who are here, if you don't mind me doing that, because there are a lot of judges past and present here, a lot of knights of the realm and dames of the realm. Kete rangatira, greetings to you, greetings to all of the lawyers who are here and the non-lawyers and everyone who has come along here tonight to find out a little bit about some of my views about international humanitarian law and how Sir Kenneth Keith influenced those matters. And I would like to say to Lady Jocelyn in particular, for us as a family of lawyers, the loss of Sir Ken Keith is a major feature in our lives, and it's an institutional, it's a foundational change for us. For you, of course, it is a personal loss as well, and we share in that with you. So please accept the aroha of all who are here on that basis. Now, I am, as is pointed out, an alumni of this very school. In fact, alumni actually of the Kelvin area up there when we were up in that particular area. And my memories of a law school from 50 years ago were largely coloured by a couple of things. One of them was that in those days, a lot of the lectures were actually presented in large lecture rooms that doubled as chemistry labs. So in a sort of Proustian way, I associate learning law with the smell of nitric acid. And I must confess, although Victoria University is my alma mater, my kāinga Wairua, that I was not the greatest student ever back in those days. In fact, I'm very much afraid that Sir Geoffrey will suddenly realise just who the hell I am. And will say, oh, I remember you. So I was a pedestrian student, would be the best way of putting it, and I was of the B's and C's make degrees variety, and I was just in the law school just now, and I saw a poster up which said, you know, today is going to be a great day. Your grades do not define you. And I thought, thank God for that. But I could not have guessed back then. And I sat in a class that was taught by Professor Keith, that this very law school would bestow upon me the honour of talking about him all those years later. Now, it's our zeitgeist, of course, that I must now declare that nothing in my lecture tonight has been produced with the aid of artificial intelligence, which distinguishes it from my essays that I sent to Sir Ken, because they weren't distinguished by any form of intelligence at all. But we've arrived, and here I am. So that's me. I've already been announced. And Sir Ken, of course, that is a wonderful photograph of him in his robe there, of course, in his role as a judge of the International Court of Justice. What's my theme for today? Well, international law and international humanitarian law, or sometimes I'm going to call it the law of armed conflict because I slip into that language, was not forged for the good times. And it wasn't forged in the good times either. Its pioneers and its pathfinders, its navigators, were all too well aware that war is a ghastly business. And that's a really good reason not to have wars. But knowing that wars would still occur, these humanitarians worked tirelessly and incessantly to invoke the strength and character of the law to try and mitigate war's worst excesses. Now, this lecture is named in honour of Sir Kenneth James Keith, Order of New Zealand, Knight of the Realm, King's Counsel, Privy Councillor, and he passed from our presence on the 13th of May 2026. Kua hingi te totara o te wāni a Tāne. A great totara has fallen in the forest of Tāne. Now, Sir Kenneth was a pioneer and a clearer of pathways, and he was also one of us. He was a New Zealander. He was a New Zealander you might bump into on Lambton Quay, and I did quite frequently. Here's someone you might meet walking along Waikanae Beach, and I did. And his hand and influence was to be felt in the law from the texts of the major treaties through to the judgments of the world's highest court. Now, it's a real trouble for me in even trying to summarise his achievements, because even if I was to read really fast, I think Mickey's big hand would be on the 1:45, and then I'd be getting the message to stop before I got through it all. So please do not write to me and say, a bit disappointed you didn't talk about the Law Commission or any of the other achievements. There is more about his career that is left out of my lecture than most people achieve in a lifetime. So you'll have to wait for the notes to come out. But I'm going to draw upon Sir Kenneth's academic writings, his teachings, his judicial decisions, and I'm also going to share some personal reminiscences along the way to demonstrate that. And I'm going to try and demonstrate that through that international humanitarian law is not only worth fighting for in a time when it's all too often treated with flamboyant disrespect, but in truth, respect for international humanitarian law is a necessity. Now, I'm going to admit, as almost every speaker today has done, as a sort of a caveat on the beginnings of their speech, this is not an easy time to sell international humanitarian law to an audience. It's not an easy time to sell international law in its entirety to an audience, even if that audience is full of international lawyers itself. There are many breaches of that law to be seen around the world today. Many, many breaches to be seen around the world today. And if, again, I was to try and read out those listed breaches, I think even at breakneck speed, I would not get through them before it was time for me to stop. So, and they're accompanied, I think, by what is possibly more disturbing, and Chris Siroti, who's the first speaker today, pointed this out, by a flamboyant flourish that such rules are stupid or simply don't apply to the special circumstances in play, or there's a new reality that the law of war simply doesn't deal with. And you know something? I've heard it all before. And it often doesn't seem to me to work out very well for the people who are advocating that line of thought. So if you do want to get a bit of an idea of what's going on, a quick look can be gained by examining the docket of the International Criminal Court, or you can look at the internet and find out a lot of things from there. Sir Ken was a prodigious producer of lectures and articles, and Professor Google will reveal scores, if not hundreds, of examples. I think he was possibly one of our most prolific scholars. Having read through many of those articles and attended more than a few of the lectures, I can say there are two frequent themes to the way that Sir Ken went about his work. One was that he was a proponent of storytelling as a method of getting his message across. And the second one was that he was a great lover of a good book. And it was not unusual for him to break out such a good book from time to time and read out passages to his audience and tell them why they should like that book and why they should read it. And following his lead, that's exactly what I'm going to do tonight. Despite the advertiser gave the title, I do not propose to lecture to you. I do not propose to grab a copy of the Geneva Conventions and start at Article 1 of Geneva Convention 1 and read in a dull monotone from there onwards, much as I would enjoy doing that. I instead intend to talk to you about a few instances and a few stories. And like most good films these days, and certainly those that win Oscars, it's not going to start at the beginning and finish at the end. I'm going to jump backwards and forwards in time just a little bit. So my first story commences not with Sir Ken, but actually with Lady Jocelyn. And it's set in the town of Delft in the Netherlands. And Sir Ken and Lady Jocelyn were there, nearby The Hague, of course, because Ken was a judge of the International Court of Justice. He was the first New Zealander ever to be so appointed, and so far the only one. So all of you young people out there, pay close attention. Listen carefully, and who knows, but you might make it yourself. I was there because I was attending a meeting of the World Justice Forum, which is a project dedicated to strengthening respect for the rule of law internationally. And Dame Susan might remember that particular project, because we ended up in Singapore on one occasion. A very worthwhile project. Now, as many people in this room will know from their own experience, Ken and Jocelyn were always consummate and generous hosts. They were wonderful hosts to any wandering New Zealand international lawyer who happened to end up in The Hague. They are also very fine hosts to any international lawyers who happened to wander to Wellington. So I was picked up actually at the train station, and on the Saturday morning, when neither of us had anything to attend to, they took me for a tour around nearby Delft on a Saturday morning. That's what I'm talking about. That's Delft. There we go. Okay, so this is going to be that's going to make you want to go there. So they took me for a tour around nearby Delft, and we wandered down a cobbled street, and all of a sudden, Lady Jocelyn swerved off the path a little bit and started heading in a direction quite quickly, and in a swift and determined manner, towards a street market. And Ken and I followed. We're about to engage in one of the most important of the obligations under IHL, namely dissemination, and incidentally, suppression of breaches. Jocelyn's target was a tent, a white tent, and on the side of it was emblazoned a large red cross. I'm right, aren't I? A large red cross. And she walked up to the young man who was tending this particular tent, and it seemed a bit odd because it didn't seem to fulfil any humanitarian function, nor was it fundraising. I think it was actually selling pot plants. And Lady Jocelyn said to the young man who met her, why exactly are you displaying a red cross in a tent that has no humanitarian function? And he replied, well, I bought it from the Dutch Army surplus store, and it had a red cross on it when I got it. And Jocelyn said, well, that's not really good enough, is it? I mean, that symbol is of fundamental importance, the preservation of life and dignity throughout the world. That symbol has stood to halt, to cease, to mitigate endless suffering, to save countless lives throughout the world. And it's really important that it's respected. At that stage, the young man said, oh yes, but that's only in like war and stuff, isn't it? And I said, oh God, don't do that. And at that stage, I said, right. At that stage, Sir Ken came forward and he said, no, that's not really right, is it? That's not really right. It's actually protected in peace and in war. At that stage, the young man felt that he should probably concede the point and accept that indeed the symbol of the Red Cross is one of the most important humanitarian rules, and its proper use has since 1865 saved thousands of lives. Now, I don't know for sure what the young man did about this. He said he was going to cover it up, and I'm pretty sure he did, actually. But if he had decided to argue the toss, that would have been unfortunate, because Sir Kenneth, of course, was the leader of New Zealand's delegation to the 1977 conference on the additional protocols to Geneva Protocol 1, to Geneva Conventions, I say, additional Protocol 1 and additional Protocol 2. And amongst the very many other things that were covered by that was a recodification of the protections of the Red Cross. And I see Marnie looking at me very intently because, of course, when she was in Afghanistan, she would have realised and seen on a daily basis just how important that symbol is and continues to be. And he would have been in difficulty there. And I might say, just to add here, we're talking about a law for tough times written in tough times. 77 was a tough time. There was warfare throughout the whole of Southeast Asia. There was a genocide fermenting in Cambodia. There was political violence, the length and breadth of South America. There was a Cold War going on. And so it was a pretty difficult ask, even at that stage, to get people to sign up to some new and important rules. And yet, of course, that's exactly what people who championed this era of law did. They put their ideas forward and they gained acceptance, I should say, and exception. They gained acceptance throughout most of the world. A very large percentage of the world now subscribes. There are a couple of notable exceptions, but most of those rules now are accepted as being part of customary international law. And of course, he would have been doubly in trouble because of Jocelyn's long-time involvement in the Red Cross here and internationally as a leader within the Red Cross movement. And she told me that actually both she and Ken had been in the junior Red Cross at the age of, 10 or something? 10, right? So they'd been working their way up to this for some time. So at the age of 10, they were in the junior Red Cross, and some callow youth would have been well advised to back off in any argument about the importance of that sign. Justin also mentioned to me that Sir Ken apparently, one of his memories of that time, one of his few memories, is that if you dropped a bandage, you lost 10 points from your Red Cross badge. I think, was that right? There's 10 points he was going to lose for that. Anyway, respecting IHL is one of these rules here, that one of the lessons from that little story there is that IHL doesn't take a day off. IHL does not take a day off because you're on holiday on a Saturday. IHL works 365 days of the year. Now, the mention of Delft, I might add, should send a tingle through the veins of all true international lawyers, and collectors of blue and white crockery. And if it doesn't, then shame on you, because Delft was, of course, the hometown of Hugo Grotius, or Hugo de Groot. And Hugo de Groot was a father, in a way, a father of so much of what is now part of our international humanitarian law. And incidentally, Delft was also the seat of Leiden University, the oldest university in the Netherlands. It was also the place where William the Silent was killed in the first ever political assassination with a pistol. It wasn't to be the last, unfortunately. And this is all in the context of what we call the 30 Years' War, but the Dutch call the 80 Years' War. And that ghastly, ghastly conflict, which killed somewhere between 20 to 25% of the population of Europe, more in some places, and which resulted in the torture and murder of anyone who was a religious dissenter or a political dissenter or anyone who was thought to be a witch, that resulted in plague and famine sweeping all across Europe. That was the anvil on which so much of what we now call international law was forged. And if we'd been around then, we might have said to Hugo de Groot, Ken might have said to him, Hugo, this is a tough time to be writing a book about restraint in warfare. Hugo might have wondered who he was going to get to publish this, I think. But again, Sir Ken might have said to him, Hugo, it's tough times, but this is not our first rodeo. That's a quote from the Post, by the way. under a title of a grand bloke, they said that Sir Ken had said, "This is not our first rodeo." Somebody else has said it too, I think. That's the best rendition of it. And Hugo might well have agreed with that, although he probably would have wondered what a rodeo was. But nevertheless, he did go and write his book. And amongst the other people who adhered to that book was Gustavus Adolphus, probably one of the most successful of the military commanders during that ghastly war, who apparently kept a copy of the Law of War and Peace next to his Bible in his camp, in his tent, in his camp. So, tough times, very, very tough times, and yet the humanitarian instinct is there to try and do something about this. And how tough are times for respect for medical workers right now? Well, I'll tell you how tough they are, that the number of global fatalities of medical personnel and patients has doubled from 944 in 2024 to nearly 2,000 in 2025. And that figure continues to rise. This ongoing crisis still persists. And that's a decade after the United Nations Security Council passed its resolution 2286, intended to protect health facilities, patients, and healthcare workers in armed conflicts, passed unanimously by the Security Council. And 10 years have gone by and the casualties are going up. And that includes hospitals that have been hit by accident. It includes hospitals and facilities which have been hit in breach of the obligation to take constant care in the choosing of targets, and it includes attacks which have been deliberate. So this is one of these times when really the world at large and all of us should be saying, well, no, that's not right, is it? There comes a time when we have to say, that's not right, is it? Now, one of the times when Sir Ken said, well, that's not right, is it, was when the French tried to tell us that setting off nuclear bombs in the South Pacific was none of our business and only really related to their particular needs for security and defence. And Sir Ken, as an advocate for New Zealand in 73, 74, and then again in 1995, certainly said to the French, well, no, that's not right, is it? And that set a path which was really now part of New Zealand's culture of an aversion to nuclear weapons. And Trussa Dunworth, who is here somewhere, there you go, Trussa, is the inheritor of so much of that, along with the great team that you went to the UN with, and which eventually produced for us a treaty on the prohibition of nuclear weapons. So that's a New Zealand tradition, and it's one of the things, interestingly enough, that when people are asked, what is it that makes New Zealand New Zealand, very frequently say our anti-nuclear stance. It is one of the most common responses. Now, as promised, I'm now going to jump backwards and forwards a little bit in time, and I'm going to jump back to my first memory of Ken, and like so many people in this room, I suspect, that was at this very law school, or to be precise, the Kelburn campus, and that's, in those days, Sir Ken taught constitutional law, and that was a second-year subject. Now, back in those days, there was a variety of the Socratic method in use. And it was, how shall I say this? Well, some people probably enjoyed it, but I personally did not. That'd be the best way of putting it. Only really the brainiest students could face the returned spirit of Socrates with complete lack of fear. I found Professor Keith, however, who, as I say, taught constitutional law, to be a kindly lecturer, at least to me. And when he asked questions, he gave you a pretty good chance of finding the right answer as long as you listened to the question carefully enough. And that's because he used to ask questions which suggested their own answer. That's what we lawyers call leading questions. He used to ask leading questions in the Socratic method. And so if young Mr. Reardon was sitting there and was about to be skewered, he could say to him something along the lines of, well, it must be the case, mustn't it, that customary international law forms, and has always done so, part of the common law, and is therefore part of the law of this country. And if you had listened carefully, you could say, oh yes, absolutely, just what I was about to say myself. And you would get that much coveted tick next to your name. Some of my classmates, I might add, still nevertheless said, oh, I don't know. And I'd go, oh God, don't say that. Yeah, if you listen carefully, you can get the right answer. Now, there's two little lessons out of that. And the first one, that tale two of the pathfinding roles of Sir Ken. One was as a teacher. He was a teacher that lectured in constitutional law, and many of New Zealand's greatest lawyers and judges, and me, learned from him about constitutional law at a time when maybe it didn't have the understanding and the focus that it now does. And he was, from my experience, one of the first of the legal scholars and jurists who really incorporated international law into the mainstream of New Zealand law. Now, he would never have said, of course, that he was a leader in that or a pioneer, but to me, he was. This was a time when I saw that development being produced before my very eyes. And when, of course, he then got to the bench of the Court of Appeal, we started to see the names of international cases, concepts that were produced outside of this country, forming part of our own law and being recognised as such. He also wrote a highly influential chapter that sat and still sits in our Cabinet Office manual. And that sets out an idea of the Constitution of New Zealand. And of course, when you live in a country that doesn't have a constitution in a single written document encapsulated or codified as supreme law, that Sir Geoffrey thought I was going to stop at doesn't have a constitution there, and I saw him twitch. But I went on to say, in a single document, and having something set out in something like the Cabinet Manual Office is a jolly useful thing to have. And I have actually heard people sort of refer to it as our constitution, which is an interesting twist. This is what he said about international law in that. He said matters of international concern mean that more and more law is now made through international processes, not domestic ones. And the powers of national governmental institutions are correspondingly reduced. And this has important consequences for national and international constitutional processes. Nowhere is this more obvious or important than in respect of international humanitarian law. International humanitarian law is absolutely and inarguably part of the law of New Zealand. And that includes, of course, the very many statutes which now give domestic effect to that law. The Geneva Conventions Act and its subsequent amendments, the Anti-Personnel Landmine Prohibition Act, the Cluster Munitions Prohibition Act, the protection of cultural property in armed conflict. All of these aspects, did I say cluster munitions? I'll say it again. Cluster munitions prohibition. All of these things are now fundamentally part of our law, and they're part of our penal law. You can go to prison for breaching them. And beyond that, there is that massive body of customary international law, which is incorporated into our own common law. And of course, an area of study which is now producing very tangible results is the extent to which Te Kanka Māori is also part of our customary law. And so these ideas that our law is constrained within some very few acts and easy to isolate is no longer the case. Much of our law is now produced elsewhere. It's produced beyond our shores. And if that's true in respect to those acts, it's also true, very importantly, in respect of Defence Force orders, which are law, subordinate legislation. And they are the rules that bind the members of our armed forces when they are in operations, including outside of this country. Now, I want to talk for just a moment because, as I said, that's one side of the story, and there's another side to the story as well. And that other side of the story is that not everybody buys what I am trying to sell here. And you can leave if you're one of them. But not everybody buys this. And it's a funny thing, but those who have the instinct to apply rules to constrain the horrors of war are apt to be described as following a sentiment, the humanitarian sentiment. Whereas those people who don't want to subscribe to that sentiment are apt to call themselves realists. And that's the advantage of being able to pick a name for yourself. And I've just got a picture up here, a picture being worth 1,000 words. And there's a bit of a contest here between some different ideas historically. And almost all of these appeared somewhere in Sir Ken's lectures. All right, so I'm going to ask a question here. If people can sort of yell out the name of who I'm pointing at, and if you get them all right, the chocolate fish. Now, there's two benefits to me saying that, and one is that merely saying the word fish is enough to amuse all of our Australian guests. But secondly, it puts some skin in the game. All right, so let's start out. The austere gentleman here on the left, right at the top, who can tell me who he is? So what are we looking at? As you're looking at top left, who's he? Anybody? No, nice try. He's on the right. Every question becomes right eventually, Rod. Yours just isn't right yet. But when we get to it being right, I'll come back to you. All right, so no, it's Clausewitz. General Karl von Clausewitz. And he wrote a book called On War. Thank you. He wrote a book called On War. He was in no danger of being prosecuted under the Trade Descriptions Act. His book is entirely about war, and mostly about what a jolly good thing war is, and how you should go and pursue it ruthlessly if it is in the political interests of the state that you serve. And he talked about international law. He actually said, there is this thing called international law, but its effect is so slight that it is scarcely worth talking about. Scarcely worth talking about. Okay, so for Professor Rod Alley only, who's the one on the other side there? Henry Dunant, thank you very much. Henry Dunant. Who was Henry Dunant? Founder of the Red Cross. Okay. He was a banker. He was not a lawyer. He was a chap who was trying to raise funds. He was trying to raise funds from Napoleon III, as it happened. He wasn't a very successful banker either. He eventually went bankrupt. But he came across the Battle of Solferino, 40,000 casualties in one day. 40,000 casualties in one day. And he came across the valley, and what had everybody done with the wounded, the sick, the dying? What did they do with them? Correct, nothing. They just left them there. And Henry Dunant decided that he would start a highly humanitarianly driven movement to protect and respect the wounded, the sick, and later the wounded, sick, and shipwrecked, the people who had been the victims of war. So there you have two highly contrasting views of the world. And we can sort of go through the rest of these people here, and they tend to fall on one or other side of that divide. So Chris Griggs will probably know Admiral Jackie Fisher. Yes, he's nodding away. Admiral Jackie Fisher, who actually was the chap who created the Dreadnought fleet for England. And he went to one or other of the Hague Conventions, and he was so cautious as to say, look, if we go to war, the best way to deal with it is when you capture the enemy, you boil them in oil. And that way, no one will ever attack you again. When he got home, he got a note from the Foreign Office saying that it was not His Britannic Majesty's view that admirals should be talking about boiling people in oil, at least not allowed. And he said, well, perhaps it had gone a little too far, but he nevertheless said the idea of restricting war through law is absurd. Absurd. On the other side here, we've got Alexander, Tsar of Russia, St. Petersburg Declaration. He was, though he did not live to see the Hague Conventions, that was his son, he nevertheless, or his grandson, he nevertheless set in train a humanitarian movement to constrain the means and methods of warfare. And then we have Lieber, Francis Lieber. Talk about tough times. The nation he was living in, the United States, was about to split itself into two violent camps in which brothers fought on either side of that divide. He knew this was going to be a ghastly war, but what he tried to do was to put in place rules that would constrain that violence and that horror as much as was possible to do. And then we then go down to the next line here, and we have Henare Karatoa of Naitarangi, who was a lay preacher, and his influence was to be seen at the Battle of Pukehinahina or Gate Pa. And if you just indulge me for just a second here while I get my screen back, I will then... then we'll move on to that. And he, of course, taking scriptural guidance, drew up a set of rules that we're just going to talk about in a second. But we would be fools to think that the New Zealand wars were fought with restraint and humanity and adherence to the laws. If you've read anything about them, you will know that that was not the case. And for every example in which humanity and restraint and control and care and aroha was delivered to the fallen and to the captured enemy. There were cases like Ngā Tapa Pā, where 122 prisoners were marched to the edge of a cliff and shot serially and their bodies tossed over while the colonial commanders stood and watched. So this is not a story which only goes one way. Now, I mentioned before about books, and Sir Kenneth had a very, very large collection, very large library. And one of the things that he would do from time to time was sort of push you in the direction of a book. And one of the books he pushed me in the direction of was The Institutes of Justinian. And I was going to read out from that, but I'm just looking at that big hand and I'm thinking, no, I might just save that. The other one he handed out was this one, and this is actually a first edition, and it's called Gate Pa, and it's written by Gilbert Mayer. And it deals with the Battle of Pukehinahina, and for those of you who don't know about that very interesting battle, Naitarangi and other associated iwi, took the had a power position. The British and colonial forces attacked. They suddenly and inexplicably panicked. They were killed in large numbers, and the prisoners were taken, were cared for, were treated. There are indications that people took water to the wounded, and they followed that. But one of the things which is enduring, and one of the things actually, Sir Ken, when he sort of found this, he said, Kevin, he said, this is one of the few things that I found and you didn't. He said, I found that, and it wasn't in any of your writings about the history of the law of war in New Zealand. You're absolutely right. You got it first. Now everybody uses it. Everybody uses this example, and so they should, as long as we just bear in mind that there's another side of that story as well. So this is the letter that was sent by the leadership of the defending tribes, and it was written, they believe, by Hanari Kapto. And it's a set of simple rules. And the first one, I'm going to do the PowerPoint karaoke here and just come back over here and say, friend, do you give heed to our laws for regulating the fight? So here you have the defenders doing two things. They're writing to the enemy. They're writing to Colonel Greer and they're saying, friend, you, the enemy, do you give heed to our laws for regulating this fight? An invitation to the British Army to comply with legal constraint on the use of force. Rule 1, if wounded or captured whole and the butt of the musket or the hilt of the sword is turned to me, he will be saved. So there you have this fundamental rule from customary international law that goes back to the birth of the subject, that if you surrender at your discretion, you are entitled to be respected and protected, and you are saved from violence. And you are, in our modern language, a prisoner of war. If any Pakeha, and I think probably everybody in the room knows that Pakeha means European in that context, being a soldier by name should be travelling unarmed and meets me, you'll be captured and handed over to the direction of the law. A rule which says if we capture you, we'll deal with you against the dictates of the law, not our own sense of morality, not our own feelings on this, but we will have a legal understanding of how it is that we are going to deal with you. Then we have the soldier who flees, being carried away by his fears, and goes to the house of the priest with his gun. Even though carrying arms, will be saved. I will not go there. Now that's a really good deal for the soldiers, I might add, and it's not exactly what modern law of armed conflict says either. But one of the things that's quite interesting is that it does have the concept of a zone in which the warfare will not be carried on. The house of a priest will be a protected zone. And then the unarmed Pākehās, women and children, will be spared. Protection of non-combatants. Now, I've got to say, these are 4 very simple rules. And if the armed forces of the world adhered to just those 4 to this day, then a substantial amount of the horror of war would be mitigated, if not completely removed. And that was in 1864. It was before the coming into force of the Geneva Conventions. Predated the Geneva Conventions. It was part of what seems to me to be a humanitarian instinct which was sweeping the world at that time. But it's not the full point either. It wasn't always the way that things were done during that time. So, just to move on a little bit here. So, as I say, the great pathfinders, the people who founded this humanitarian concept of law, were realists. They were realists. They knew what war looked like. Many of them had fought in wars. Many of them had seen what happens in wars. To describe them as being sentimentalists is, of course, a very derogatory approach, and it enables you to sideline their belief. Similarly, it seems to me that when you looked at that group before, particularly with the Clausewitzes, with people like Admiral Fisher, with that idea that you could actually further your political aims by brutality, seems to me to be a very non-realistic approach to the world. And it's an approach that some very short period of time later resulted in 70 million people being killed in the First World War. The idea that you could impose your will on another state and that they were then at your mercy produced not only the destruction of empires, but the destruction of whole races of people. The second book that no, I won't. I'll skip the second book because I just want to get to. That's a good book. I mean, Justinian. Well, he had it pretty much nailed. No, you'll have to go and read that one yourself. We've moved on from there. The rules of the fight, and I'm just now going to sort of try and tie a little wee bit of a bow around this. When I first wrote this speech, I had the idea of a sort of a theme of, I've seen law in action and I've seen no law in action. In the course of my service as a soldier, as an officer, I went to places where the law was not in evidence. And I've been to places, and I live in one, in which respect for the law is a commonplace. We understand it. And believe me, that's better. No law is not good. But I decided to actually strengthen that up a little bit. So rather than me just saying, look, respect for international humanitarian law is good, I'm saying it's necessary. It's a necessity. It's a necessity for our survival. This is an existential issue. So why do I say that? Well, largely because the massive destructive power of humankind is now so vast, so pervasive, so scientifically developed, and actually so cheap, that a failure to understand, or I would say re-understand, the need to constrain ourselves even in the extreme circumstances of war is to end our existence, and that's what I call a necessity. Now, the conference has started with a whakatoki. It tells us that the well-steered canoe can cross even the most stormy sea. I have another whakatoki with a nautical theme as well, actually, and that's koe mate wheki, me mate ururo. The wheki is the octopus. Ururoa is the hammerhead shark. And what that says to us is that when you are in a situation where you are facing all types of adversity, don't die like the octopus. Die like the hammerhead shark. Fight it out to the last. Now, I think that's a little unfair on octopuses, to tell you the truth. Because I think that the octopus is a little bit like international lawyers. It's an intelligent being. It's gentle and inquisitive and dexterous. Gentle in its habits. And when it gets into trouble, it sprays a lot of ink everywhere. But nevertheless, the point remains that if this subject is worth fighting for, and I would say it is worth fighting for, then we should not just come along quietly in the face of flamboyant statements that say that what we're doing is a waste of time, or that our time has come and gone. There's no future for this because the rules-based order is of no value, and every nation now should simply do what it pleases if it can, and those that can't must put up with what is imposed on them. And we can either accept that, or we can, like the Ururoa, the hammerhead shark, put up a bit of a fight. And we should not be afraid, like Sir Kenneth Keith, to say, well, no, that's not right, is it? So my message really finishes there, and I think pretty much bang on time. I would like to say that Sir Ken was of a generation which achieved so very, very much in international humanitarian law. And many of you, my friends, my colleagues, my whānau here, have worked on areas of international law and have developed it and worked on it and championed it. And there are people here who are the next generation. And to you I say, if you want to pick up this challenge, then pick it up and go for it, because our existence might depend upon it. So good luck. Thank you very much for your time.
Thank you. That was wonderful. And we do have some time for questions. If you've got a question, just signal and Leah or Em will get a microphone to you. We will now pause for that awkward moment until the first question starts.
You know, I actually did this to Sir Ken once. I brought him along to talk to a conference, and he so comprehensively dealt with the thing that then they asked for questions like no one dared move. And it became a little embarrassing. So if you don't ask me a question soon, I'll just ask one of myself. So please point to we have a question.
Thank you for the wonderful lecture. For those of us who are not law students, but who are in the international relations, strategic studies space, do you have any recommendations on what we can kind of do to help foster more respect for IHL in our area? Because obviously that's not going so well right now.
No, it's not. No, you're right. But as I say, it's not ever been going all that well all the time. I think, you know, someone said to me once, most states comply with most of international law most of the time. And there's a few sort of big areas outside of that most, isn't there? And then you then have sort of periods of time where you will have almost a champion of anti-IHL. Jumping at the bit, and I return to this point that if someone says something to you like that, says you know, what you're saying has no value, that your area of law is not even a real area of law, then I would suggest you say, well, no, that's not right. And if you can have some good examples sort of in your mind of how to do that, I just ask, are there any Germans here? I made a terrible mistake with this once because I referred to Clausewitz, and the person I was talking to thought I was talking about Hitler. and that soured relationships for a little while. The reality is that when you have that sort of pushback there, one of the questions I ask is like, how's that working out for you? I mean, really, I've been in. It's not my first rodeo either, and you look at things like the treatment of prisoners at Abu Ghraib, and the combined committee of the Senate and Congress in America produced a finding saying torturing people produced not one piece of actionable intelligence that was of use to us, but what it did do was it diminished the respect with which the United States of America is held. So that's them talking, that's not me talking, that's them talking. So there's so many examples where you sort of look at it and say, so you're going to flagrantly disregard the law. How's that working out for you? And the chances are that the answer is not so good, actually. And there's so many practical advantages to actually working within a framework where everybody knows. And by the way, sure, one of the questions that will often be asked is if we're not actually being a bit hypocritical. I see a few people nodding their heads there because they've had that one. Are we not being hypocritical when we are saying let's advance a rules-based system, but that rules-based system actually disadvantages certain nations on Earth hugely disproportionately? Is that not hypocrisy? And of course, sometimes some of those issues are well made. I often think about a book that's written by Aldous Huxley. So I told you I'd bring a book in. So a book written by Aldous Huxley called Jesting Pilot. And he actually addresses this straight on, and he says, he talks about Kant, not Immanuel Kant, but Kant as in saying things that you don't really believe in. And he said, actually, when you boil it right down, that's kind of useful, because if you say it often enough, you do start to believe it. And secondly, if you're being held to that standard, you are going to modify your behaviour, even if you don't actually believe it. Right? So I'd rather have a lot of people who are subscribing to a set of rules that they don't entirely believe in than a whole lot of people subscribing to no set of rules at all.
We do have time for one more question, if there's one more out there.
Hi, thank you, Malcolm Jorgensen. You've characterised critics of international humanitarian law as realists, but of course there are some from the other side of politics, if we can put it broadly. People like human rights professor Samuel Moyn has criticised IHL for saying that it humanises war and therefore reduces the incentives to avoid it, which seems like it's perhaps an abstract point, but there was a speech given by the Ministry of Foreign Affairs at the Otago Foreign Policy School in the last week, where, for instance, they emphasised the obligations of the parties to comply with international humanitarian law in the Iran war, but without emphasising some of the breaches of law and going to war in the first place. So that makes that rather concrete. So I wonder what you would, if you could respond to this potential other critique of international humanitarian law.
It's one of my favourites. Absolutely. A famous series of writings. It says essentially international humanitarian law is the legitimisation of violence. The mere fact that you have rules of international law which recognise military necessity tells you that this is a law that actually allows you to kill people. And it allows you to kill them not because of what they've done or what they are doing, but because they wear a different coloured set of clothes from you. And that's a worthwhile and a respectable argument to say there are two sides to this argument, and one of them is that actually if you have a law which says, well, you can kill people this way, but you can't kill people that way, then you've got a big problem, because the first part said you can kill people this way. The contrary argument, however, is, and by the way, that is an argument that Leo Tolstoy, for example, he had one in War and Peace, another book, War and Peace, please read it. War and Peace, one of the characters, one of the counts in that, actually rails against the idea that you should have constraint in warfare. He was saying if the French had known how cruelly we are going to treat their prisoners, they would never have come into the country in the first place, and then we wouldn't have had to be cruel at all. I kind of doubt that proposition, to tell you the truth, and I think that even though at a theoretical or conceptual basis you might say, well, aren't we actually just making war more palatable by putting these rules in place? Well, for some countries, some nations on earth, war is pretty palatable no matter what rules you have in place, and I'm not entirely convinced that doing away with all of them will make much of a difference one way or another to that palatability. I think the other thing too is that in the meantime, you're talking about human beings who are being tortured, who are being murdered, who are being starved to death, who are being held in indeterminate confinement with no cause, and those people are suffering now. And if you were to say to them, but you realise, don't you, that this is actually dissuading other people from having a go, they would say, I think I'd rather have the Red Cross come and help me right now, please. So, you know, there is that argument. It's a legitimate argument. Yeah. Thank you very much.
We'll let Kevin take the load off his feet now, and I'll take the opportunity to invite Sir Kenneth's son, Ben, to say a few words.
Thank you, Vice-Chancellor. E ngā mana, e ngā reo, e rangatira mā tēnā koutou. I have the honour and duty and burden of offering a thanks after that wonderful lecture. It was extremely kind of Judge Reardon to take it on in the first place, and that burden has grown only heavier since my father's passing in mid-May. I also do want, before I forget to do so, to thank the ANCIL organisers, in particular Marnie Lloyd, whom you've already heard about. She reminds me why the word indefatigable is needed in the English language. Now, this has been the third instance of the lecture established in my father's honour, and of course the first since he passed away. I do want to take this opportunity while we're among so many friends to thank many of you who have sent messages of condolence and kind reminiscences to my mother, to me, to many of our family. But I also want to say a wider thanks to you all and to ANCIL. As many of you, anyone who encountered my father on a really crisp Canberra winter morning on the last day of the old-fashioned Saturday ANCIL conferences will know he was an irrepressible fan of trans-Tasman legal relations. As you may know, he had the supreme good judgment to marry an Australian-born New Zealander in 1961, and he in fact passed away on their 65th wedding anniversary. But that was only the first of many important, valuable, hugely productive, well, including me, I suppose, trans-Tasman connections. A better example might be that of the nuclear testing cases of which Judge Reardon has already mentioned. For a very small band of New Zealand and Australian lawyers, and when you see the photos, they look impossibly few and impossibly young to take on a nuclear-armed state and force it to stop nuclear testing in the Pacific. Well, that was my panui at school when I was about 5, about what my dad did at work. And I don't think anyone's ever topped that or could. But it was a joint effort. New Zealand, as my father occasionally and slightly tactlessly pointed out, did a better job, but we did have Australian support. And that, of course, continued throughout my father's career, culminating in his election first to the International Court of Justice and followed by his Australian friends, Professor James Crawford and then Professor Hilary Charlesworth. I said I'd be brief, or in fact I've been told to be brief, and I will be. What Judge Reardon has reminded us of is that we do not dare forget even in grim times, even in surreally awful, in some respects, times, what I think my father did believe, which was that through hard work, collegiality, simple humanity, even the most appalling global problems can be addressed. Very early on in my international law training, I think I was about 7, I had read the Shire history of Nazi Germany, because it was a really big book on my parents' bookshelf, and I was at that age where the bigger the better. Also, I was trying to impress my sisters who are here and who still aren't impressed. And so I read about death camps, and I read about pogroms, and I read about just the casual cruelty, and I read about Josef Mengele, and I still remember all of those things vividly about 45 years later. And my father somehow noticed I was a bit unhappy, and he worked out what that was about. And his reaction was not to tell me off for reading an inappropriately aged book or suggest I could go back to Fantastic Mr. Fox. He told me about his friends. He told me about Quentin Baxter, who went to Tokyo. He told me about Colonel Draper, whom I later met, this fearsome ex-military international lawyer who had been the first British lawyer to go to Belsen. And then he told me about Lieutenant Kelly. You may think this was a little bit heady at age 7, and possibly parenting books would agree with you, but the common thread in all of those things, and I will begin to thank Judge Reardon in a moment, is that we cannot despair. We don't have to despair. There are answers to these things. They are imperfect, and they are hard, and they are sometimes harrowing, but they work, or rather we cannot, as Judge Reardon has said, it is necessary that we hang on to them, because the alternative is not just despair, it is destruction. If you can please join me in thanking Judge Reardon for reminding us all of that and of the example that my father represented. Thank you, Judge.
Thank you, Ben, for those wonderful reflections and for concluding the formal parts of our event this evening. Shortly, I'll invite everybody to join us for refreshments on the mezzanine floor, but it simply remains to ask you to join me one last time in acknowledging Sir Kenneth Keith and our amazing speaker this evening, Judge Reardon. Thank you so much for your